Assalamualaikum warahmatullahi wabarakatuh. This is part 2 for the lecture recorded via Zoom. The topic is consideration. So in part 1, we have covered the definition. We also covered the first two types, which are executed and then executory. For this part, we are going to discuss past consideration. It's going to be quite a lengthy discussion on past consideration alone. So what is meant by past consideration? So the word past here, it gives you some hints actually. Because why? It means it consists of something, the act, which was wholly performed, wholly done before the making of the promise. If we were to draw a timeline, so the act was done first, was completed first, then only comes the promise, okay, about the act later. Okay, so in other words, yeah, okay, the past act was done or it was omitted, not in response to the promise. So normally, in normal situation, promise will come first, then it is followed by the act. But for the situation of past consideration, the act was done first, later there comes the promise. So what's the rule governing past consideration? So in other words here, when we talk about past consideration, the promise is made, okay, subsequent to the act or omission, okay, the act or omission. And most of the time, okay, the promise is independent of it. That's why we have a unique rule governing past consideration. Okay, another explanation here. Okay, if one party voluntarily performs an act or the other party then makes a promise, so this is what we mean as past consideration. So consideration for the promise is said to be in the past. So we have the rule at common law. We also have a rule in Malaysia. Let's have a look at common law first. So at common law, the rule is that past consideration is no consideration. In other words, it is not valid. It is not enforceable. So the parties cannot base their suit on past consideration. Example here, okay, simple example. A gives B a lift home in his car. And once they arrive, okay, on arrival, then only B promises to give A £5, okay, towards the petrol. Mean that, yeah, okay, there's an act of giving a lift, okay, sending B back home. And then B say, okay, I'll pay you, okay, for your act here, for sending me home. But let's say later B does not want to pay £5 here. So can A go to the court? Can A sue B, okay, based on the promise? So at common law, the rule is that A cannot enforce this promise because why? His consideration, okay, giving B a leave, this is something in the past. Okay, there's no promise by B towards A before, okay, the act of giving a leave home here. All right, so that's basically the sequence. So the act was done first, and later there comes a promise. And if there is any changes later, no performance or no payment, all right, as promised. But I mean, it's not possible, okay, to sue in the court of law because why? It is not a valid consideration in the eyes of law. This is the rule at common law. Let's have a look at the case. This is quite a classic case here. In re McArdle, this is, okay, in re actually it refers to in a matter of. So it relates to the property belonging to McArdle, reported in year 1951. What happened here? Plaintiff, okay, plaintiff was carried out some improvement, okay, repairing on a bungalow. And actually this bungalow had been left in trust to her husband and siblings of the husband, okay. And then after work has been carried out, okay, by B, B is the wife lah, obviously here. The siblings, okay, sign a document stating, okay, because you have done some improvement, repairing on the work, on the bungalow here, okay, stating that plaintiff should get certain amount of money, £488 here, from proceeds of sale because they wanted to sell off the bungalow. And later, okay, the siblings didn't actually pay plaintiff, okay, for the work done. So payment was not made. And the court held that the promise given by the siblings here was not unenforceable, cannot be enforced because why? All the work by plaintiff here had been done before the promise to pay. Okay, the promise to pay was made later. So whatever promise actually here, it is considered as past consideration. So cannot be sued. Okay, I mean the suit cannot succeed based on past consideration. But again, in order to balance the rule, okay, common law also has some exception to the rule. One of the important exception is previous request. Meaning that here, in order for the plaintiff to be successful for the claim based on past consideration, so it has to be made. It has to be brought under this particular exception. The exception is previous request. What does it mean here? So if the promisor, okay, has previously asked the other party to provide goods or services, then a promise made after they are provided will be treated as binding. Meaning here, if there is any request, even though it's not a proper promise, it's just a request, then yes, it's possible to enforce the promise based on the previous request. Let's have a look at the case here. A very, very classic case here. This is 17th century case, Lampley and Braithwaite, 1615. 17th century, okay. Braithwaite, he killed someone, okay, and then he asked Lampley to get him a pardon. So Lampley got the pardon, so he gave it to Braithwaite, and Braithwaite promised to pay. Okay, I'll pay you, give £100 for all the trouble, okay, to get the pardon on my behalf. So the court, but later there's no payment. All right, that's why we have the case here. I mean, Lampley is suing Braithwaite. So the court held that although Lampley's consideration was in the past, I mean that yeah, he got the pardon first, then only the promise to pay later. But the court held that Braithwaite promise here to pay, okay, actually can be linked. They could be linked to Braithwaite earlier request. You are the one who requested for the pardon, okay? So the court treated all the things here as one agreement, one long agreement, basically. So it could be implied, okay, at the time of the request that Lampley would be paid, even though he didn't pay, he didn't say I'll be paying you, but because of the request, so impliedly, I mean, it is possible for you to pay later, to make a promise to pay later. So all the things here, they are all treated as one agreement. So request here comes with the inference to be paid later. All right, let's have a look at past consideration under Contracts Act. Okay, Malaysia's position. So we have Section 2D Contracts Act. I have reproduced certain parts, relevant part for our discussion, which actually relates to past consideration. And we are going to look at Section 26B, which talk about exception, okay, as well as illustration C. Okay, if you read through Section 2D, okay, we are going to focus on this part. It is stated here, blah, 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 okay, has done or abstained from doing. So has done something in the past actually, or abstained from doing something in the past. So this shows that even if the act or omission was prior to the promise, okay, but such act or omission would constitute good consideration, okay, so long it was at the desire of the promisor. I think let's have a look at the actual wording. Okay, we go back to Section 2D. 2D. Okay, 2D here. Right. It started with a desire. Okay, desire. Mean that here, this is what the promise wants. Okay, what the promise wish or have the desire. So when at the desire of the promisor, okay, the promisor or any other person has done in the past, okay, has done or abstained from doing, or does or abstain from doing. Okay, the word is has done in the past, okay, or abstain from doing, but it must satisfy elements of at the desire of the promisor. Then only it is recognized as valid consideration. Okay, and then we are going to have a look at Section 26B and also illustration C. Okay, we go back to here, 26, okay, 26B, specifically B and illustration C. Here. So agreement made without consideration is void unless, okay, B here, is a promise to compensate for something done. Okay, meaning here, it is a promise to compensate wholly or in part a person who has already voluntarily done something. Meaning here, the act comes first, okay, voluntarily done something for the promisor, or something the promisor was legally compellable to do. We go to illustration C. Okay, here A finds B's purse, okay, and give it to him. Okay, in a promise. Meaning only action by A. Okay, and then returning B's purse here, and later comes the promise. Okay, B promises to give A 50 ringgit. So is it a contract? Was there consideration between them? Yes, there was, but it was in the past. But this is a contract, valid, enforceable contract. Because why? Okay, we relate to B just now. Yeah, right? To compensate. Meaning to pay. All right, to pay for something already done later. All right. So it's possible to sue or to enforce the. Based on the promise here. We go back to the slide. Okay, so the things that we learned, okay, the in short here, have a look at the arrow here. Okay, the first one, in Malaysia, past consideration is recognized. Okay, first it has to be at the desire of the promisor, and it is if we refer to section 26B just now, it is the act voluntarily done. Okay, no need to prove at the desire, because if under section 2D, it is at the desire. But if the act is voluntarily done, okay, by the one who does the act, then again, it is something which is valid and recognized in the eyes of law. So the party, okay, has to prove either of these two elements. Okay, otherwise, okay, we just apply the normal rule. Past consideration is not valid. It's not recognized. But if the party, okay, if the plaintiff can prove, okay, it falls under either of these two situations, yes, it is valid and recognized. It is enforceable, even though it is past consideration. Let's have a look at the case law. This is a local case. This is to illustrate a situation in Malaysia. The case is Hong Kong and Shanghai Banking Corporation, or the acronym is HSBC. Okay? And Syarikat United Leong Enterprise Sdn Bhd, reported in year 1993. What happened here? We have few defendants. Okay, the first defendant is the company, okay, of which second defendant and his wife were directors. Meaning that here the company were owned by two parties here, defendant and the wife. Okay, husband and the wife. So all of them here. Okay, the company was a customer for the bank lah, basically. Okay, of the HSBC, and then the bank gave loan. So loans were given by plaintiff to the first defendant. So it was given to the company, okay? And the loans were secured by charges and debenture. So it's normal. Okay, whenever a loan was given, so it has to be secured, something in charge. Okay, in case there's any default of payment later. And what happened was that later the company was unable to repay the loans. Okay, so now Hong Kong and Shanghai Banking Corporation (HSBC) demanded payment, okay, from the first defendant, from the company. And because of that, okay, there's another transaction here. There's another document signed. A guarantee was signed, okay, by the director, okay, second defendant. But even despite the signing of the guarantee, okay, no money was advanced, okay, after the execution of the guarantee. So now the bank sued the defendants for the money lent, okay, to the first defendant and guaranteed by the second defendant. So now, because the guarantee came later, at a later stage, okay, during payment of the loan. So now the issue was that whether the guarantee was void for lack of consideration. But the court held that, okay, the defense of unenforceable past consideration or no consideration must fail. Because why? The court referred to section 2D and also section 80 of Contracts Act. And these two sections actually lay down that past consideration can be good consideration, okay, for a guarantee, even though benefit was given before execution of guarantee. Here the loan came first, then only the guarantee came later. Okay, provided it is considered as one of transaction, I mean it relates to one another. Okay, like in the present case, so benefit was given to the principal debtor. Okay, it was given at the desire of the guarantor. Okay, the director signed the guarantee desire. Okay, at the desire. The loan was at the desire. Okay, at their desire, they need the loan and they signed the guarantee. So it's considered all one of transaction, even though it's in the past. Okay, we have another case. This is also another leading case because it was decided by Privy Council. So those days before Malaysia has their own federal court or Supreme Court, so all the appeal will be referred to Privy Council, the highest apex of the court. So the case name is Kepong Prospecting Limited and Schmidt, reported in year 1968. So in this case, the Privy Council made it clear, okay, it held that past consideration is good consideration, valid, enforceable in the eyes of law. What happened between the parties here? We have few parties involved. In the year 1953, okay, Mr. Tan, okay, one person by name of Tan, so he applied for a prospecting permit for iron ore. And who was Schmidt? Okay, Schmidt is the defendant here. So Schmidt, he was a consulting engineer, so he assisted in the negotiations. And then they got the permit. Okay, upon grant of the permit, so Tan wrote to Schmidt. So Tan made some promises, okay, to Schmidt here, promising him 1%, okay, of the selling price of all ore, okay, that might be sold in payment for the work Schmidt had done. And might do in starting mining operations. So you can see in negotiation, assistance come first, later only payment to pay. I mean, later only promise to pay, okay, 1% of of the selling price, okay, of the, it's like commission lah here, right? What happened later? Later, they set another company. Okay, later Schmidt and Tan, both of them, they set up a company, and the company was named Kepong Prospecting Limited. And in year 1954, okay, company and Tan made an agreement. They put into writing, whereby company took over. Okay, initially it was Tan's obligation, okay, to pay. Now company will be the one who pay. Okay, it took over Tan's obligation to pay Schmidt 1%. Okay, so it cross-referred to 1953 agreement. Okay, it made reference to 1953 agreement that they had agreed later. Agreed earlier. And a year later, in 1955, okay, company and Schmidt made an agreement wherein company agreed to pay Schmidt, okay, of 1% of all ore, okay, that might be won from any land, okay, comprised in 1954 agreement, in consideration of the services, okay, by the consulting engineer and on behalf of the company. So whatever things here which was due for payment, first the company said, okay, whatever thing due prior to formation of the company, prior to existence of the company, and after its incorporation, and also future services. So these are all the promises, okay, the obligation on the part of the company. And later they have problem. They have the quarrel, okay. All right, so a dispute arose, okay, leading to Schmidt's dismissal. So Schmidt was eventually dismissed, okay, as managing director. So now he followed suit, okay, claiming all monies payable to him. And then he made reference to section, 1954 as well as 1955 agreement. They have signed a few agreements, okay? And then the company said, no, we are not going to pay you. Because why? Company argued that, okay, there was no consideration given by Schmidt. Here, whatever thing you did, it was in the past. No consideration, all right? No fresh consideration given by Schmidt for the obligation undertaken by the company. Even though the company promised to pay, but there's no consideration. It is like one way, okay? No payment should be done. But Privy Council had that. Well, actually, if you look further, if you look deeper, okay, there was sufficient consideration moving from Schmidt to company. And what's consideration here? The services, okay, rendered prior to the company formation, okay, of course, it could not amount to consideration, as a non-existent company cannot receive services, okay, or by itself to pay for services. Whatever promises made the company, okay, to pay prior to the existence of company, that one cannot be enforceable. But the court held that, Privy Council held that, services rendered after incorporation, okay, this one is validly amounted to consideration, okay, for an agreement. So the court made reference to section 2D. So whatever company promised to pay, okay, even though the act was in the past, after formation of the company, yes, or for the future also, yes. But if the company promised, oh, we'll pay you, even though the company was not yet established, that one cannot be enforceable. Okay, here, if we cross refer again, all right. For the first one, okay, the first arrow there, that one cannot be enforceable. Because why? How come you made a promise which the company yet to exist? Okay, how to make payment? But after incorporation, yes, even though the act was in the past, okay, promise can be enforceable, and also for future services. Okay, now let's make a comparison. Okay, Common Law and Contracts Act. So if we were to refer to section 2D, okay, section 2D actually was limited. Because why? It does not cover all cases of past consideration. Okay, under section 2D, it is restricted. It is limited only to cases where there has been prior request. So this is a condition, okay, to be proved, all right? And then without this prior request, then again, we just apply the normal rule. Past consideration is not good consideration. Unless, okay, the plaintiff, the one who wants to enforce it, okay, can prove the element of prior request. So if we want to compare with English law, okay, English law on this issue, on this point is quite similar. Because why? Okay, because the past act or omission by the promisee is good consideration for a promise if it was done at the request of the promisor. I mean that here at the desire, okay. And then the current position here, this is the latest position at common law. Okay, the rule that past consideration is not good consideration is subject to exception discussed by Privy Council in Power On. That's the latest one, even though not the most recent one, but the rule still stands good until today. Okay, in the case of Power On and Lau Yew Long. So the Privy Council made a very clear, explanation, okay, on the exception. Okay, so this is the summary. Okay, so summary from the case just now. So Privy Council said that okay, past consideration can be good consideration. Here there are three situations. Okay, the first one, the promisee performed the original act at the request of the promisor. Okay, and then it was clearly understood or implied between the parties that the promisee will be awarded for the performance of the act. I mean here by way of implication. And then the actual promise made, okay, if made before the promisee provided a consideration, must be capable of being enforced. In other words, giving rise to legally binding contract later. So this is all the requirement. Okay, this is what made it clear in the case of Power On. This is the current position in regards to past consideration at common law. Okay, this is okay. Last case before we stop for this part of the lecture. This is judgment by Supreme Court, equivalent to Federal Court. Okay, Southeast SEA. Okay, Southeast Asia Insurance Berhad and Nasir Ibrahim. This is pertaining. This is a suit, a legal suit action on the contract of indemnity. What is contract of indemnity? So it is a contractual. I put the definition there. Okay, contractual obligation of one party to compensate the loss incurred to the other due to the acts of the indemnitor or any other party. So we go straight to the issue. We focus on the issue here. The issue was that, which is relevant for our discussion, whether the third party indemnity executed by respondent was invalid. Okay, because why? On the ground of past consideration, because the performance bond signed by the appellant was dated earlier, okay, 9 August, whereas the state indemnity, okay, the promise here was dated 19 December. I mean, few months later. I mean, yeah, this is a case of past consideration. So is it valid or is it invalid? Was it enforceable or not? So the court held that in deciding whether consideration is past, okay, so the court should not take a strictly chronological view. Okay, we shouldn't limit the decision on the date alone, because the date, clearly this is something which is in the past. So past consideration is not good, it's not valid. So the court held that if the consideration and the promise are substantially one transaction, it's like one-off, it's a long transaction, but it's all one-off, it's related. As in this case, so the court held that it should not matter in what order they are given. So the date is not really important. So in other words, consideration itself, it accommodates past consideration, so long at the desire. Again, there's a highlight here, desire. Okay, desire requirement is specified. So basically, the guarantee was given, okay, at the request of the indemnifier, even though it comes later. Okay, so as it can be proved that there was consideration, okay, it can also be proved that the third party indemnity was valid, even though it happened later. Promise comes later. Okay, guarantee comes later. Right? If you want to know further, you have to read the full fact. This is only the summary which is relevant for the discussion of past consideration. Okay, that's all for part 2 of the Zoom recorded lecture. I stop share. I'll see you at part 3.